Hello students, greetings of the day. Today we are going to discuss a very important topic in law of torts, which is arising out of and in the course of employment. The plan for discussion for today's lecture is as under. We'll start with the introduction, then we'll move on to the presumption regarding accidents that occur in the course of employment. Then we will discuss components of arising out of and in the course of employment. Under that, we will discuss commuting to and from work, followed by the judicial overview on the claims of compensation, and finally, we will discuss the conclusion. Now, let us start introduction. Students, when an employee is subject to the terms of a compensation act, the employee loses his common law right to sue the employer for damages. This is a general premise. On the other hand, compensation acts do not, I repeat again, compensation acts do not in general prevent tort actions from being brought against third parties. Because of the restricting characteristics that are inherent in a variety of compensation schemes, the primary objective of this lecture will be to investigate the extent to which an employee can claim compensation from his employer, even if the employer has not done any act or omission to hurt or render injury to his employee. The phrase "in the course of employment" implies both the length of time and location of employment. That is to say, the worker was present at the place and doing his job when the accident happened, and it must have occurred at or near his workplace. In this context, employment refers to more than just the job. If the worker was technically employed when the accident occurred, even if he wasn't doing any physical labor, the claim will succeed. An accident is considered to have arisen out of and during the course of employment if the employee is just taking a break, eating, drinking, or walking home from the office. According to a judicial decision in the case of Union of India versus Mrs. Noor Jahan, the case is of 1979, a man is considered to be in the course of his employment when he is both actually performing his duty and engaging in activities related to it. Presumption regarding accident that occur in the course of employment. Students, point number 1, in this category, in the absence of contrary evidence, an accident that occurs during the course of an employee's employment shall be presumed to have originated from that employment. Point number 2, in the event of an accident occurring near or on premises where an employee is currently employed for the operation of his employer's business or trade, the incident shall be considered to have originated from and occurred in the course of his employment. If it transpires while he is responding to an actual or perceived emergency at said premises by rescuing, aiding or protecting individuals who are injured, threatened or believed to be in danger, or by preventing or mitigating significant harm to others. Point number 3, an accident that happens during an employee's commute from their residence to their place of employment for duty or from the workplace back to their residence after completing duty shall be considered to have transpired in the course of employment if there is a connection established between the circumstances, time and location of the accident and the employee's employment. Point number 4 under this heading is that an accident that occurs during an employee's passenger travel by any vehicle to or from his place of work with the express or implied permission of his employer shall be considered to have occurred in the course of his employment, even if he is not obligated to travel by that vehicle to his employer. Fifth one is, this determination is made if the accident would have been considered to have occurred had he been under such obligation. B, the vehicle was in motion at the time of accident. Now, we will discuss components of arising out of and in the course of employment. Students, to qualify as an accident arising out of and during employment, anything must be unexpected. The second component is that the harm must be reasonably attributed to a specific moment, location, event or source. The act should be generously and extensively construed to carry out its true aim and purpose. The expression arising out of suggests the cause of the accident and the expression points to the place and circumstances under which accident occurred and the time when it occurred. A causal connection or association between the injury caused by an accident and employment is necessary. The answer to each of these following factual inquiries must be established individually. When is it considered reasonable to arrive at work before or following business hours? When is voluntary participation in an activity no longer mandatory? When does an employer benefit substantially and directly from an employee's non-work related activities? Using this criteria, arising out of employment is evaluated following the specifics of the accident and injury in question. The positional risk exam is the most frequently administered. According to the positional risk test, any risk is considered an employment risk if the employee is exposed to it while performing job duties during working hours. To satisfy the second criterion, known as the increased risk test, the employee must demonstrate that their employment significantly heightened their exposure to the risk. The increased risk test is applicable under two circumstances as mandated by statute, and point number 2, when the employee is not actively engaged in the performance of their duties. Students, a neutral or personal risk is still regarded as an employment risk under the positional risk test if the employee encounters it directly during the employment. Students, in the case of Harvey versus Caddo de Soto Cotton Oil Company of 1942, an employee was engaged in work within his employer's hull house when the structure was devastated by a tornado. The employee passed away when the hull house collapsed. As a result of the appellate court's determination that the tornado did not constitute an employment risk, the disaster was not attributable to employment. The appellate court determined that the tragedy did not result from the employee's employment, as his duties did not subject him to higher level of danger from the tornado than the general public. In contrast, the court held a different opinion. Disregarding any evaluation of the initial cause of hazard, the tornado, the court determined that the worker's demise was attributable to his occupation, requiring him to be present at the location where the incident had transpired. Consequently, applying the Compensation Act in its lenient interpretation, the court concluded that the accident was incidental to employment. The next point for discussion is commuting to and from work. In general, commuting to and from work does not constitute travel for employment. This is also referred to as going and coming rule. Nevertheless, exceptions can be made to this principle. Transportation to and from the workplace is deemed to be in the course of employment when one considers the following conditions. Now, let us discuss the conditions. First one, if the employer demonstrates an interest in the employee's travel by offering a company vehicle, paying the employee for travel time, or reimbursing the employee for travel expenses. Point number 2, when the employee is engaged in an employer-sponsored task. It should be noted that during an employment task, an employee operates portal to portal, which means they are in the course of their employment from their place of residence to the work site or vice versa, from the work site to their place of residence. Should the incident transpire with the premises of the employer? If the employee sustains an injury while commuting between different work sites, in situations where the employee was performing work for the employer under the conditions that reasonably implied the employer's consent, should the operation of a motor vehicle constitute executing a duty inherent in the employee's employment? Now, let us discuss through the judicial overview of the claims for compensation. Students, it is pertinent to note that the burden of establishing that the accident occurred during employment is on the claimant. In the case of Chaugule and Company versus Shrimati Felicitate, the cases of 1970, the employment itself should have led to the circumstances of the accidental injury. However, a direct correlation, it's a very important point, a direct correlation between the employment and accident is not required. Injury resulting from a catastrophe in which the employee's employment is not always crucial. A personal injury deriving from employment does not necessarily have to be the result of the principal nature of the employment, nor is it restricted to the situations in which the injury is directly related to the duties that the employee is required to perform. Students, the phrase arising out of employment is defined as an injury sustained during employment that was caused by a risk incidental to the duties and which, had the employee not been performing a duty owed to the master, it is unlikely that they would have incurred such an injury. In the case of Nawab Ali versus Hanuman Jute Mills of 1933, it was held by the court that an incident of negligence must have some bearing on the employment. The compensation claim must be validated if the accident happened on a roadway where risk inherent in employment was present. Indeed, though this imprudence, the employee has exposed himself to the same risks and added to them. This expression is inherently applicable to the field of employment. Its obligation and incidents are subject to its conditions. If an employee is injured or killed in the zone of extraordinary peril due to any of these, he will be entitled to compensation. Students, the landmark case of Janki Ammal versus Divisional Engineer of 1956 established the principle that in the course of employment encompasses both the location and duration of labor. This case further examined whether a subordinate required authorization from a superior to traverse beyond their assigned territory while adhering to their directives. The subordinates believe that they are authorized to utilize labor substitutes is justifiable if the superior possesses the authority. An injury sustained while on the job should be classified as sustained within the reasonable limits. In the case of State of Rajasthan versus Ram Prasad et al. 2001, the Supreme Court ruled that certain conditions must be met for an employee to prevail in their compensation claim. In the case of Shrimati Geeta's death, the employer may still be liable if the claimant can demonstrate that the deceased was exposed through the course of employment. In the present case scenario, the disease was contracted while working on the premises and the employee would not have been exposed to electrical hazard had the site not been occupied. In the 1970 case of R.B. Mundara and Company versus Bhanwari, the descendant was employed as a driver on a vehicle transporting gasoline in a canister. The day before the accident, the employee informed his employer that tank was leaking. The appellant requested that the afflicted enter the tank the following morning to determine its source. The employee proceeded to the tank devoid of gasoline and ignited the match to detect the breach. The tank caught fire, resulting in the deceased suffering burn injuries before succumbing to their injuries. The accident would be considered to have occurred out of and in the course of employment if the action that caused it happened within the scope of employment, was incidental to it, or was in the employer's best interest. In this case, the deceased was engaged in an activity that advanced the employer's objectives during the catastrophe. Under the threshold doctrine, if the employee sustained an injury in an area immediately adjacent to his place of employment, that area posed a distinct travel hazard to him. The threshold doctrine typically governs situations involving hazardous conditions by definition, such as proximity of railroad tracks to an employer's premises, and the necessity for employees to traverse the tracks to access the employer's premises. Students, the court in the case of Robinson versus Brown determined that the threshold doctrine did not apply to a non-unique temporary meteorological condition on the employee's property. Amidst an ice storm, the employee arrived at the work to discover a notice affixed to the office door informing them of daily closure of the space. While walking from the building to the parking lot where her vehicle was located, she sustained a back injury after slipping on a patch of ice. During the incident, she was traversing a public thoroughfare. The court rejected a threshold doctrine argument because the ice storm had reached the area the day before the alleged fall and the frigid condition pervaded most of the area, not specific to the area the employee had to travel through to get to work. However, specific legal decisions have established that the threshold doctrine can apply to any hazardous situation an employee encounters in the vicinity of the employer's property, including neighborhoods with a high crime rate. In Hall versus House, Golden Kingsmill and Ross, a New Orleans-based attorney who occupied an office building, walked 2 blocks to a parking lot where his vehicle was located after leaving work at the close of the day. Students, 2 males in the parking lot carjacked him. They ultimately executed him. The court determined that the lawyer was abducted in the course of employment under the threshold doctrine because he was required to have a car for work, park in the vicinity of the office building, and all parking lots surrounding the office building were located in an extremely high crime area. In the 2008 Supreme Court of India case Oriental Insurance Company versus Saru by Gori and others, the respondents were the parents of a driver employed by the third respondent who had owned the vehicle in question since a specific date in 1996. For over 7 years, no further communication was received regarding the driver. The Compensation Commissioner granted his parents a compensation award in the amount of rupees 2.29 lakh. The High Court affirmed the decision. The insurance company filed an appeal with the Supreme Court, which granted the appeal because the driver had not been involved in the accident that was a direct result of his employment. The Supreme Court noted that there was no evidence in the record to support this claim. If the driver was murdered or the vehicle was stolen due to an untoward incident, there was no basis to establish a presumption that the death was the result of an accident deriving from employment. Moreover, it was necessary to ascertain the rights of the involved parties as of the date of the collision, prior to which any information regarding the motorist could be obtained. The court determined that the presumption established in section 108 of the Indian Evidence Act could not be used to support the claim. Next in the line, in a railway compartment, an employee was stabbed to death who was employed to perform repairs at multiple stations during his time in transit. It was determined that the employee's demise was caused by an accident that occurred in and out of the workplace and was reported to the court as occurring in the course of employment. For the employee's claim to be successful, he must demonstrate that he was engaged in the employer's business at the time of his injury or was involved in furthering that business and was not acting for his own benefit. the individual in question is required to demonstrate that he was acting in the performance of a duty imposed on him directly or indirectly by his employment contract. The Bombay High Court differentiated between arising out of and arising in the course of employment. The latter implies that the injury must have been caused during the course of employment, whereas the former signifies a different concept. Vinayak Yanku, a carpenter, was a member of the staff at the workshop owned by the appellant, which was located at Alexandra Dock, Bombay. He was provided with the workbench and a cupboard in the workshop. Apart from Vinayak, there were additional labourers present and their tables were arranged in a linear fashion. It was on May 13, 1950 that the tragedy occurred. Vinayak arrived at the workshop and occupied the designated table in order to complete the task at hand, which involved fabricating a trolley frame. An explosion of a device occurred at that location, leading to Vinayak sustaining injuries. Subsequently, he was transferred to St. George's Hospital, where he passed away that evening. The test is whether the injured person was required to risk, suffer or do the activity that caused his injury as a part of his employment. This observation was made by Lord Sumner in Lancashire and Yorkshire Railway Company versus Haile 1917 and was affirmed by the Supreme Court in Mackinnon Mackenzie and Company Private Limited versus Ibrahim Muhammad Ishaq 1970. In that case, the incident was directly related to his work, otherwise it was not. Now, coming to the conclusion. According to the ruling in Mackenzie versus I.M. Ishaq, where an injury occurs as a result of a risk inherent to the service, it is reasonable to assume that the worker would not have suffered if the master hadn't enacted that duty. The connection between the accident and employment must be tenuous at best. The worker must have exposed himself to additional risk for the compensation claim to succeed if the accident happened due to a risk that was an event of the job. The employee must provide evidence that he was actively involved in the employer's business or furthering that business at the time of the injury, not performing the action for personal gain or accommodation. The inquiry should consider whether the employee was obligated or anticipated to perform the action that led to accident, even though he could have performed same task prudently or obediently. In other words, could the injury causing act have been removed from the employee's employer specific responsibilities to render the accident unrelated to his employment. When an employee performs job duties during work hours, the employee is acting in the ordinary course of employment. When an employee is not performing job duties, is away from the employer's premises or has not yet begun or completed working, the course of employment becomes less noticeable despite being on the employer's premises. Students, before and after work hours, the employee is deemed to be employed for a reasonable duration. The employee will be considered engaged in the course of employment if the employer requires participation in an activity outside of work hours or away from the employer's premises, or if the employers obtain a significant direct benefit from such an activity. Students, this puts a liability on the employer to pay compensation in case of injury or accidental death of his employee. With this, We come to an end of today's lecture. Thank you so very much for the patience listening.